file a trademark in the United States, you will be asked for a unique request where you'll have to decide whether to file your trademark application as a use-based application or an intent-to-use based application. If your mark is already in use, then it's most likely that you'll file based on use. This is called a 1A basis because you are filing based on the provisions of the U.S. Trademark Act Section 1A. To file based on use, you'll need to state a date that you first used the trademark to sell a product or service, and you'll need to submit a specimen showing your present use of the brand. This will be evidence of the nature of your use and prove that you have used a trademark for the goods and services that you're going to claim in your trademark application. If you have a date of use and evidence of that use, then you can file based on use. Now, this is much easier and less expensive than filing based on intent to use. However, you can only claim the actual goods or services that you use and not what you might use in the future. For example, if you only sell bicycles and you also want to sell bicycle parts, then your trademark application must only claim bicycles. If you claim to have used the mark for bicycles and bicycle parts, but you don't sell the parts, then your application will forever be susceptible to challenge for fraud. The U.S. trademark regime is very particular about this. Now, if you want to file a trademark application for a mark that you don't use yet, or service that you don't offer yet, then you have to file based on intent to use. This is called a 1B basis application because you are filing based on the provisions of the U.S. Trademark Act, Section 1B. The downside of the intent to use trademark is that you cannot actually register the trademark until you actually use the trademark in interstate commerce and file a statement of use and pay an additional fee to the trademark office. When you eventually do file a statement of use, you will have to delete any goods or services that you are not offering and that only state the use for the things that you actually sell. Whether the application is based on use or intent to use, you can ultimately only register for the goods or services you actually offer. Now, you can get a broader list of goods while the intent to use trademark application is pending, but when it registers, you will have to remove any goods or services that are not being offered in interstate commerce. In practice, if we choose 1A that is actually using the mark in commerce, then we are required to submit a specimen of use and identify the date we first started using the trademark to sell the specified goods or services. If we choose 1B, that means there's no use yet, and we're intending to use it. We won't have to submit a specimen because we haven't used it yet. Now, the USPTO makes sure to warn you that you cannot claim anything you're not actually using. Otherwise, it will be a violation of the law and punishable thereunder. Now, after the registration process is complete, if the application was based on use, 1A, you will then receive a registration certificate in the mail. If your application was based on intent to use, 1B, instead of a registration, you will get what's called a notice of allowance. Once you have been allowed, all you have to do in order to mature your application to a full registration is make use of the mark in interstate commerce, file a statement of use, and pay the fee. Now, if you haven't made use of your trademark within 6 months of receiving the notice of allowance, you must file an extension. You can file up to 5 of these extensions, which each give you 6 more months to submit the statement of use. Once your mark is registered, you don't have to do anything for the first 5 years. But between the 5th and 6th year, you must then file a renewal and pay a fee. The next renewal is at the 10th anniversary, then another renewal at every 10 years thereafter. Again, there are no reminders issued by the USPTO, and as such, many marks go abandoned at the 5th year and even more at the 10th year. Please feel free to watch more of our videos to get valuable insights about the mechanics of applying for trademark registrations, defending your marks, opposing other conflicting marks, dealing with office action, and many other intellectual property issues. My name is Jonathan Morton, and I am a licensed U.S. attorney, a partner with the law firm of Morton & Associates, and a member of the Trademarkers Network. Thank you for watching.